The United States Supreme Court just issued a major order, although I want to talk with you, Harry, about its implications because the concurring opinion by Justice Sotomayor sought to really curb, I think, the damaging effects of this Supreme Court order. It relates to Donald Trump's executive order, basically dismantling departments and agencies and ordering that a reduction in force assessment is done across the board to reduce, as what DOJ was basically doing, getting rid of and firing all these people who work at the various departments and agencies. And so a group of labor organizations filed in a federal court in California, which blocked this executive order several months ago, I think at this point, that Donald Trump was implementing. And they said, look, you can't just issue these executive orders that go ahead and dismantle departments and agencies. You got to do it with Congress. Congress created the agencies and departments. You need to have a law. You can't just do an executive order on it. So Trump appealed an injunction that was issued by a federal court in California to the Ninth Circuit. The Ninth Circuit kept the federal court's order in place. Trump runs to the Supreme Court. And this is part of the trend that we've been seeing, Harry, here, is that what the Supreme Court did is that they stayed or paused the district court's order. And the district court's order was an injunction blocking Trump's executive order. And so by pausing the district court's order that blocks Trump from dismantling these departments, it basically allows Trump to do it during the pendency of the case, which can last, many years. And by the time it goes back up to the Supreme Court, too bad, so sad, everybody's fired. Now, what Justice Sotomayor says in a concurring opinion is hold it. She goes, I don't like what the Supreme Court is doing, but she said the Supreme Court simply saying that Trump can issue an executive order that calls for something to be done, but they're not specifically saying that what he's doing at the agencies is okay yet. For that, we have to look at the individual reduction in force documents and plans that are being implemented on a department by department, agency by agency, sub-agency by sub-agency basis to then see if that is consistent with the enabling statutes that exists for these agencies and departments that Congress passed. So Sotomayor saying, yes, they're saying you can issue an executive order, but that's like saying presidents can issue executive orders on any topic. This doesn't mean that it's actually legal. Sure, the president can then say, do a reduction in force analysis, but only until we see a reduction in force, how that results, can we determine whether it's valid or invalid. So Sotomayor gives a roadmap back to the federal courts to say, well, they're invalid reduction in force models. I'm still going to issue an injunction. Trump regime, you're going to have to now challenge hundreds of orders across the country on each specific reduction in force. But then you have Ketanji Brown Jackson, who basically says, I really don't care. You're allowing Trump in a dissent. You're allowing Trump to go and even issue an executive order like this. I'm paraphrasing here. I really don't give a crap if what you're saying is he still has to have reduction in force orders that are okay and logical and consistent with the agency's enabling that. She goes, this is not what, you're not allowed to do this. This is for Congress. Go and pass a law. Stop with these stupid executive orders. All right, Harry, I broke it down, and I think an unintelligent way by saying stupid executive orders. You were a top DOJ official. You led the federal prosecutor's office in the Western District of Pennsylvania. Break it down for us.
Okay, so look, the basic notion here, Ben, is that it's unlawful, or at least by the lights of the dissenting justices, to simply wipe out the different agency workforces. And it sure appears that that's what Trump is doing. It's lawful, potentially, to sort of trim around the edges, reductions in force for efficiency and the like. But we have the same problem that the court green-lighted before, which is what's happening now on the ground. Is it the A, little bit of trimming okay, or B, the really sort of vast kind of wholesale, absolutely, taking a sledgehammer to it? We have reason to think it's the latter. The complaint says it's the latter. And what the Supreme Court is doing in saying, in keeping the district court stay order from going into effect, is basically greenlighting, as you say, for potentially years, this whole situation until an actual case ripens and works its way up to them. Imagine for the moment, it's not very hard to imagine, that what he is doing is unlawful. And by the way, the reason would be made very clear in both the concurrence and even more in Jackson's dissent. This is Congress's lookout. If you're trying to do more than trim around the edges and do little efficiency reductions in force, you got to work with Congress. Now, of course, that's the very kind of cross-cutting claim that has been made repeatedly, and the administration seems indifferent to. But that is what is the supposed distinction. But if they are on the wrong side of that distinction, there, as you say, too bad, so sad. Come months or years from now, the restructuring has already taken place. And that's why there's a common theme, it seems to me, of what the court is doing wrong. It said blithely, we think that the executive, based on what it's saying, is likely to prevail on the merits. That's the first factor for granting a stay, in their case, in granting a stay of the stay. But there are three others, and one of them is irreparable injury. And this is the same thing, Ben, that comes up in the alien cases. Give me a break. On the one hand, you have an administration that might have to hold off a little bit in its grandiose plans to winnow out or just totally, blow cannon holes in the whole executive workforce. On the other, you have person after person after person is going to lose their job, lose their livelihood. The representatives of the organizations that you say can represent their claims. So I find it completely puzzling what the court even thinks it's doing. And what does it say, by the way? It says we think they're going to prevail on the merits, and the other state factors are qualified, are satisfied also. Maybe, could you maybe give us a sentence or two on that? So what we're having is the court coming in again, undoing what a district court has done. And make no mistake, if the administration is, as its record would show, going farther than the law would permit, this is, in practical terms, a huge order, the kind of thing that will take years to recover from, totally gut the efficiency of so many agencies in the, this has Doge and Project 2025 written all over it, and therefore it has the same ignorance and ill consideration of all the effects that are going to happen if they do the things they have said. And what the way the court has really abetted it now is by first having probably a controversial holding about what's likely to succeed, but as Sotomayor tries to say, it's just the succeeding here just means they're doing this little trimming around the edges, and that's okay. But I don't think that's what we're going to see. But more importantly, the whole stay analysis has been really rejiggered in favor of the administration and against the interests of individual persons whom Trump's orders here and elsewhere are completely ravaging.
You and I have discussed, this seems that the Supreme Court's plan is either one, just to fully enable fascism, or complete appeasement of the Trump regime, and not to issue an order that the Trump regime could actually disobey, that shows that the court no longer has any power at all. So they issue decisions that look more like limericks, or as I've described it, going up to the top of the mountain and seeing what the oracle is going to divine, like that scene from the movie 300. And it's not tethered to precedent, law, logic, and analysis that I can say, oh, got it. Here's what it is. Here's what this is. Because what Sotomayor tries to do to make sense of this is, as I said, well, all the Supreme Court saying is Trump issued an executive order, step one. Step two is Trump ordered that a reduction in force assessment be done by the departments and agencies to then do the termination. So all the Supreme Court says here is Trump issued an order to do a reduction in force assessment, which Biden can do or anybody can do. I see no problem in that. And you don't know, I don't know. Is that what Justice John Roberts is actually saying or not saying, because the shadow docket decisions are not very clear? Or is he saying something more profound? And the problem is now you're going to have courts in Kentucky or in the Fifth Circuit or elsewhere saying, nope, he said something more profound. Another court saying he said something less profound. And nobody really ends up knowing. There's no clarity. There's madness, and fascism festers in madness. Final word, Harry.
Well, very well put, man. I like that phrase. Pithy, Ben, as usual. Yeah, but so look, so the dissenting judge on the Court of Appeals in the Sixth Circuit, as you've just posited, will say, oh no, Sotomayor made clear what this is. This is only supposed to be this little trim around the edges, but now it goes up to the Supreme Court on its shadow docket. And guess what? They disagree. And now the six again impose their will and say, oh no, it didn't have to be the teeny little trimming around the edges. It's okay if it's this massive restructuring, and restructuring is a nice way to put it, massive firing of the members of the executive branch, hundreds of thousands. And it's the real paradigm of the kind of case that you just can't put the eggs back together again, and giving Trump his leave to do what he wants, supposedly on a temporary basis, just while we figure it out, is in effect to let him just bring his scythe to the whole executive branch, ruin people's lives, totally destroy the functions of government and the like. And if the Supreme Court at the end of the day greenlights that, well, guess what? Sotomayor's conclusion doesn't matter. And if in fact they want to do it otherwise and it comes up to them, it still probably doesn't matter, because the 2 years or however long it's been are water under the bridge, and all these events on the ground have occurred, and the person who was working in such and such an agency has had to go and retire or leave or find another job. You can't put the pieces of government back together again, which I think for Trump and Project 2025 may be part of the idea, but that's not what the law says. But in effect, that's what the Supreme Court shadow docket may permit the administration to get away with.
And to give you the real world example, what does the National Weather Service meteorologist coordinator in the Austin region, San Antonio region do? What are the people who have been pushed out by DOGE, who our job is to forecast and coordinate these? What does the FEMA administrator who was working in Florida do? What do you do, and what is the impact, the real life impact, not this theoretical cosplay fascistic, Dungeons and Dragons game that the Supreme Court thinks these are our lives that are at stake. Harry Litman runs the Talking Feds YouTube channel, the Talking Feds podcast, and the Talking Feds Substack. So what that means is on YouTube, when this video ends, search Talking Feds, hit subscribe, and watch Harry's daily takes there. Go to Harry Litman's Substack, the Talking Feds Substack, or wherever you get your audio podcast, search Talking Feds and listen to Harry there. Thanks so much, Harry.
Thank you, Ben.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.